Handwritten documents come to notaries all the time. If you want to see how you can handle a handwritten document, keep watching. One of the most common issues is that handwritten documents usually don't include notarial certificates. I mean, they're handwritten after all. But a notarial certificate is absolutely necessary to perform a notarization. If your client comes with a handwritten document that doesn't include one, you'd ask them what type of notarization they need so that you can attach the right certificate. Sometimes your signer will have no clue what type of notarization they need, and in those cases, you want to be extra careful not to choose for them. Choosing the type of notarization for your signer is considered an unauthorized practice of law, which is illegal and could land you in serious trouble. What you can do is have your signer contact the requesting agency or look at different types of notarial acts and determine which one they'd like you to perform. From there, you can proceed with the notarization and attach the right certificate form. If you have a printed certificate, great. But if not, you can handwrite the certificate wording or stamp it using a certificate stamp, either directly on the document or in a separate sheet that you can attach. Another thing to be cautious of when dealing with handwritten documents is something called a holographic will. A holographic will is handwritten by the person to outline their wishes after death. The person who writes the will is called the testator, and they create it without an attorney, without a witness present, and usually without having it notarized. In fact, in certain situations, holographic wills can be invalidated completely if they're notarized. Some states recognize holographic wills as long as they are completely handwritten and signed by the testator. But in many states, these wills are not accepted because without witnesses or legal guidance, it's hard to prove that the testator willingly drafted the will. To protect your signer, you should never notarize a will unless you've been given clear instructions from the authorized source, like a qualified attorney, on how to proceed. Because these are complex legal documents with strict requirements, you should only notarize them if you've been provided clear instructions and/or a notary certificate accompanies the document. There's one more common issue to be aware of, which is less to do with the documents and more to do with how people view notarization itself. Not everyone understands what a notary actually does. Some people believe that having a handwritten document notarized automatically makes it legal or official, but it doesn't. If your client says they're notarizing a handwritten document to make it legally binding, don't hesitate to remind them that the true purpose of notarization is to confirm the identity of the signer, their willingness to sign, and that they signed under the right conditions. Handwritten documents are legal to notarize, but they require extra care and clear communication. Follow these guidelines to protect both yourself and your signers when handling them. And remember, if you have any questions, NNA members can reach out to our hotline for guidance anytime. What else would you like to see from us? Drop your suggestions in the comments below, and don't forget to subscribe and hit the bell so you never miss out on a new video. We'll catch you in the next one.